Hello everyone, and welcome back to our series on the Indian Constitution. If you RIABC aspirant or just someone keen to understand the bedrock of our nation's governance, you've come to the right place. Today, we're diving deep into a very crucial, albeit short, part of the Constitution, Part 20. This part contains just one article, but its significance is immense. We're talking about Article 368, which deals with the power of the Parliament to amend the Constitution and the procedure for it. So, grab your notebooks, and let's get started. First things first, why do we even need a provision to amend the Constitution? Well, our founding fathers were visionaries. They understood that a constitution is not a static document. It needs to be a living, breathing entity that can adapt to the changing needs and aspirations of society. They wanted to create a document that was flexible enough to evolve with time, but also rigid enough to prevent hasty or ill-conceived changes that could damage its fundamental principles. This delicate balance between flexibility and rigidity is the very essence of Article 368. So, what exactly does Article 368 say? It lays down two primary methods for amending the Constitution. Let's break them down. The first method involves a special majority of the Parliament. This is the most common method used for amendments. For a constitutional amendment bill to pass under this method, it must be supported by a majority of the total membership of each House of Parliament, and by a majority of not less than 2/3 of the members of that House present and voting. Let's unpack that. Majority of the total membership means more than 50% of the total strength of the House, regardless of whether there are vacancies or absentees. For the Lok Sabha, with a total strength of 543, this would be 272. For the Rajya Sabha, with a strength of 245, this would be 1-3. Then comes the second condition, a majority of not less than 2/3 of the members present and voting. This means that of all the members who are present in the House and cast their vote, at least 2/3 must vote in favor of the bill. Both these conditions must be satisfied in both the Lok Sabha and the Rajya Sabha. For the bill to pass, most parts of the Constitution can be amended using this special majority. For example, provisions related to fundamental rights and directive principles of state policy are amended through this process. It's a stringent process, ensuring that any change to these vital parts of the Constitution has broad consensus within the Parliament. Now, let's move on to the second method of amendment, which is even more rigorous. This method requires a special majority of the Parliament, just like the first one, but with an added requirement: the ratification by the legislatures of at least half of the states. This ratification must be done by a simple majority in those state legislatures. Why this extra step? This method is reserved for amending provisions that relate to the federal structure of our country. These are matters that affect the distribution of power between the center and the states. Think about it, it would be unfair for the Parliament alone to change the rules that govern its relationship with the states. So, the states are given a direct say in the matter. What kind of provisions fall under this category? The list is quite specific. It includes the election of the president, the extent of the executive power of the Union, and the state's provisions related to the Supreme Court and High Courts, the distribution of legislative powers between the Union and the states, any of the lists in the 7th schedule, the representation of states in Parliament, and even the power of Parliament to amend the Constitution itself, which is Article 3. Any amendment to these entrenched provisions requires not just the special majority in Parliament, but also the consent of at least half of the states. Now, you might be thinking, is that it? Are there only 2 ways to amend the Constitution? This is where it gets interesting. While Article 368 explicitly mentions these 2 procedures, there's actually a third category of amendments. Certain provisions of the Constitution can be amended by a simple majority of the Parliament, which is the same as the procedure for passing any ordinary law. This means a majority of the members present and voting in each house is sufficient. However, and this is a crucial point for your exams, these amendments are specifically excluded from the purview of Article 368. The text of the Constitution itself allows for these changes to be made by a simple law. Examples include the admission or establishment of new states, formation of new states, and alteration of areas, boundaries, or names of existing states, creation or abolition of legislative councils and states' rules of procedure in Parliament, and provisions related to citizenship. These are seen as necessary operational adjustments rather than fundamental changes to the constitutional framework. So, to recap, we have 3 ways to amend the Constitution: by simple majority, by special majority, and by special majority with the ratification of half of the states. But only the last two are governed by Article 368. The history of Article 368 is also a story of a long-standing tussle between the Parliament and the judiciary. The big question has always been, is the Parliament's power to amend the Constitution absolute and unlimited? This question led to a series of landmark Supreme Court cases. It started with the Shankari Prasad case in 1951, where the Supreme Court held that the power of Parliament to amend the Constitution under Article 368 also includes the power to amend fundamental rights. The court argued that the word law in Article 13, which says that the state shall not make any law that takes away fundamental rights, refers only to ordinary laws and not to constitutional amendment acts. This view was reaffirmed in the Saijan Singh case in 1965. However, the tide turned in 1967 with the famous Galaknath case. In a landmark judgment, the Supreme Court reversed its earlier stance. It ruled that fundamental rights are transcendental and immutable and that Parliament has no power to take them away. It held that a constitutional amendment is also a law within the meaning of Article 13 and would be void if it abridged any fundamental right. This judgment sparked a major confrontation. In response, Parliament passed the 24th Constitutional Amendment Act in 1971. This amendment added clauses to Article 13 and Article 368 to clarify that Parliament has the power to amend any part of the Constitution, including fundamental rights, and that such an amendment will not be considered a law under Article 13. The ultimate showdown came in the historic Kesavananda Bharati case in 1973. This is a case you absolutely must know inside out. The Supreme Court, while upholding the validity of the 24th Amendment Act, came up with a brilliant and novel doctrine, the Basic Structure Doctrine. The court ruled that while Parliament's power to amend the Constitution is wide, it is not unlimited. It cannot alter the basic structure or fundamental features of the Constitution. What constitutes the basic structure? The court didn't provide an exhaustive list, but it gave several examples, such as the supremacy of the Constitution, the republican and democratic form of government, the secular character of the Constitution, the separation of powers, and the federal character. Since then, the court has added more features to this list in subsequent judgments, including judicial review, the rule of law, and the principle of equality. This doctrine of the basic structure has been a cornerstone of Indian constitutional law ever since. It establishes a fine balance. Parliament can amend the Constitution to adapt to changing times, but it cannot destroy its core identity. It ensures that the soul of our Constitution remains intact. The judiciary acts as the final arbiter and guardian of this basic structure. So, in essence, Part 20 and Article 368 are not just about a dry legal procedure. They represent a dynamic interplay between the legislature and the judiciary, a continuous dialogue about the nature and limits of constitutional power. It reflects the maturity of our democracy, where the Constitution is supreme, and its fundamental principles are protected against arbitrary changes. For your UPSI preparation, it's vital to understand the nuances of the amendment procedures, the key differences between them, and the evolution of the law through landmark judgments like Galaknath and Kesavananda Bharati. Remember the concept of the Basic Structure Doctrine. It is a frequent topic in both prelims and mains. Understand not just what it is, but why it came into being and its significance in preserving our constitutional democracy. I hope this detailed explanation of Part 20 has clarified the amendment process for you. It is a testament to the wisdom of our Constitution makers who created a framework that is both resilient and adaptable. Keep revising these concepts, and don't hesitate to ask any questions in the comments below. Thank you for watching, and if you found this video helpful, please give it a thumbs up, share it with your fellow aspirants, and subscribe to our channel for more in-depth content on the Indian Constitution. We'll see you in the next video.